So was the acquittal of Salman Khan almost a given considering the shoddy probe that had been conducted against him, the glaring loopholes that have been pointed out by the court in its judgment? Joining us on debate number 1 on Newshour tonight is Abha Singh, advocate and social activist. We have actor Nagma also joining us, along with Hitesh Jain, advocate, who will be joining us in a bit. Sujay Kantawala, senior lawyer, live from Mumbai. Aniket Nikam, criminal lawyer in the Bombay High Court, is also with us. And it's an open debate. We're going to take points of the prosecution's case one by one, and you can, all the panelists can express their views about it and talk about it, contradict each other. It's an open debate right at the outset. Abha Singh, I would like to start with you. First point, why could it not be established right at the beginning whether Kamal Khan's testimony was important or not? Why was Kamal Khan not brought in? That is something which the court has also spoken very strongly about.
Abha Singh, if you've been able to hear the question, this is something that you've also brought up in court. This is something you questioned in court. The issue of Kamal Khan and why it was not considered absolutely necessary to the case to bring him in.
Absolutely. In fact, before the session court was giving the judgment, we had filed that petition. We had shown the court that Kamal Khan is needed for this case, because if there are going to be loopholes in the High Court and Supreme Court, the case may fall flat. We were worried about that, and that is what happened, because Kamal Khan was the only star witness who was alive and who had said in front of a senior police officer that it was Salman Khan who was driving the vehicle. So what was the compulsions on the prosecution that it did not insist on getting Kamal Khan, when Kamal Khan had given an undertaking that he may be allowed to go abroad for his mother's treatment, but he would come anytime when he is called back. So neither the prosecution called him. Even in fact, if the High Court felt that Kamal Khan's testimony was required, then 386 of the CRPC has a provision that High Court could have sent the case back to session court.
So Aniket Nikam, as someone who says that the Mumbai police did the best that it could, how do you explain this glaring lapse?
Procedural lapses cannot be used to obliterate justice, to deny justice, which has happened today. So these procedural lapses cannot be the ground to leave Salman Khan. Even today we don't know who was driving the car. If Salman Khan was not driving the car,
I challenge
that's
Salman
the question.
Khan that tomorrow he should
eventually
go to at the end,
and lodge a case against the Bandra police.
The day today, the big question is, if Salman wasn't driving and Salman wasn't drunk, who killed that one person and injured the 4 others? Who killed Nurullah is the big question. Then I'm going to try again, Aniket Nikam, if you can actually hear us. You know, the fact that Kamal Khan's name was actually dropped from the list of witnesses, the list of prosecution witnesses, which went down from 67 to 34 over the course of the trial, doesn't that completely defy basic common sense and logic? As Abha Singh said, the man who was in the car, a prime eyewitness, as per the prosecution, one of only 3 people in the car. Why would he not be brought into court during the trial?
Yes, I will answer that. I will tell you, there were 2 eyewitnesses other than Salman Khan himself. One was Ravindra Patil, who was his bodyguard, whose statement came to be recorded, who was the first informant. He was the complainant who had registered the FIR. The second gentleman was Kamal Khan. Witnesses have testified and said that Kamal Khan was with Salman Khan that night. Now, Salman Khan's statement was initially recorded by the police. But let's not forget the fact that Salman Khan is a British citizen. After his statement was recorded, he was allowed to go abroad and he never returned back. Now,
but the fact is that he was in the country till 2007. And the summons was issued to an old Mumbai address was his.
Yes, I agree. Summons was issued to old Mumbai address of his, but they should have made more efficient efforts in getting him as a witness. That's number 1. Number 2, let me also tell you that the defense
and that
in
is
High
the point,
Court
that how can you say that the investigation was efficient? You had a new address which was given in 2008, yet you never even bothered. You sent the summons to an old address and then said, well, you know, he never really responded.
I'll tell you, it is the prerogative of the prosecution whether to cite a person as a witness or not for reasons that are there in law. But let me also tell you that even if Kamal Khan was a witness, eyewitness to the incident, there was a possibility. I do not know what was dwelling in the mind of the prosecutor at that point in time or the investigating officer.
But that is the question.
Let me just complete. There may be a possibility that Kamal Khan, being friends with Salman Khan, he would not support the case of the prosecution.
But
They might have thought that citing as a witness.
But that's contrary to what he had originally said. The first statement that Kamal Khan made in 2002 was saying that I was in the back seat of the car and it was Salman driving and Ravindra Patil sitting next to him. This is what Kamal Khan himself said in 2002. Hitesh Jain, how is it therefore that he was not considered an absolutely prime witness during the trial and not brought in by the prosecution? Sujay Kantawala, let's put that question to you.
In fact, this is one of the most glaring things that comes to my mind. Apart from the other things, the learned judge has gone into all the facts. He has taken his own time. He has gone into all the arguments. Thereafter, he has juxtaposed it with the law. So therefore, the learned judge has given a well-reasoned judgment. And what the High Court can do in appeal is only go through the records already before the High Court. So therefore, I feel that a lot of questions are going to be raised on how the prosecution has conducted its case and how the investigation was done.
Aniket Nikam, would you concede it was a shabby investigation?
See, once again, let me just tell you that this was a case, or this is a case which has been in limelight from day one because of the person who is involved as an accused. Now, in a case of such gravity and magnitude, I don't think that the investigation will be purposely or intentionally shabby. There may be slipshots in investigation, there may be discrepancies, there may be loopholes, but of course it would not be intentional. And to say that it was intentional or purposeful would be misplaced at this moment. Now, I agree with you. I agree with you that Kamal Khan might have been cited as a prosecution witness.
Why was it delayed by 10 years? Why was the case kept in cold storage?
Yeah, Abha Singh, go ahead, respond to those points. The thing is that if the judge has picked
exactly, see, exactly, the case was kept in cold storage.
Yeah, go ahead.
Exactly, the summons were not issued. They could not find the witnesses. Half the important witnesses disappeared. The police said that we cannot locate the witnesses. I mean, there were total 62 witnesses, and in the magistrate court only 17 could be done, and finally at the time of trial only 27 could be located. And today's world, is it possible with digital footprints that you cannot find the witnesses? So from day one, Mumbai police was trying to derail the case. In fact, when Kamal Khan was such a crucial witness, why was he dropped? Why was his testimony not taken?
I completely disagree on the fact that Mumbai police is trying to derail the case. Let me tell you that initially the offence was 304A. It is Mumbai police who slapped 304 Part 2, which is culpable homicide not amounting to murder. Then Salman Khan challenged it before the Sessions Court. He went to High Court. High Court said that 304 Part 2 is not applicable. It is Bombay police who challenged it in Supreme Court, and Supreme Court set aside the order of Bombay High Court. So it's improper to say.
What we're going to do, Abha Singh, we will go through each of the points that the Bombay High Court has talked about in the order, where the Bombay High Court has in fact punched holes in the prosecution's case. Abha Singh, 1 second, let the others come in.
Then why are you not fixing the responsibility?
And in fact, I want to bring in Nagma at this point. Do you agree with the theory that there was a deliberate attempt to try and botch up the case, Nagma? Opening comments from you.
No, that's
Look, I'd like to say that unfortunately our judicial system does need a lot of reforms. We have nearly about 3 crores, approximately 3 crores cases which are pending before the court. There are about 1.4 crore people who are having criminal cases against them.
No, but here, Nagma, the question is of a faulty investigation. What option does the judge have?
I'm answering your question. I'm answering.
Yes.
Give me a minute. I'm answering your question. I'm saying that there are so many people who are languishing in the courts because of the cases that they have against them. Maybe they don't even deserve the kind of punishment that they've already received by just being in the jail.
And we're going to bring up some of those cases a little later on the show.
It has been 13 years that this case is on, and if the judicial system was the way it was, it had to be better. Then justice would have been there for everyone, because this case should have been finished in 2 years and not.
No, but the fact is that's the point, though, Nagma. In 13 years,
the victims would have also got justice. That we all want the victims to get justice.
We want your response to the fact.
Torture also.
We want your response to the fact
that he and his family went through the.
Fair enough. They've been awaiting this verdict for 13 years. But the question here is that in these 13 years, what it's come down to today, is that the prosecution has essentially failed to establish either that A, he was drunk, or B, that he was driving. So bringing it, coming back to what the judge has actually said in his order today.
It's very unfortunate that why do stars really have to face this? Why is it only when it comes up to stars this case is questioned? I mean, I would say that any innocent man should get justice. It's not about Salman. I'm talking about all those other victims also. I'm talking
the innocent man died. The innocent man died has not got justice. And my biggest problem is that if Ashok Singh was driving the vehicle, why did Salman Khan not mention this in the statement? Why did it take 12 years that Ashok Singh was driving the vehicle?
Look, that is clear perjury.
We can all see the truth, but we can't get to the truth. It is surprising. It's appalling.
But in fact, Abha Singh, Abha Singh, we'd like to get more clarity on this particular point that you're talking about. This particular point that you're talking about.
You are not ready to believe in the Indian Evidence Act. When the chemical analyst says...
You're talking about this particular issue of Ashok Singh coming up 12 years later, and the judge, in his wisdom, has also made observations on that, talking about the fact that it is normal protocol or procedure that the defense witnesses will come towards the end of the trial. If you could just shed a little more light on exactly why the judge has completely disregarded what the prosecution was saying with regards to Ashok Singh showing up at the end of the trial.
Ashok, in Salman's statement, nowhere it is mentioned that it was Ashok Singh who was driving the vehicle.
Yes.
Why did Salman Khan not give his statement in the inception saying that it is Ashok Singh, not me? Why did he take the charge of Ashok Singh on him? And if the court felt that it was Ashok Singh who was driving the vehicle, why did the judgment not say today that start the prosecution proceedings on Ashok Singh?
But
very happily you have
that's what I'm asking you.
Important issues.
Abha Singh, that's the question. That's what I'm asking you.
Who was driving the vehicle?
If Ashok Singh shows up 13 years later and says I was driving, that's the question.
Why could you not engage a good lawyer if the prosecution was unable to establish the truth? Where was the shortage of not getting a competent senior counsel to defend the government? For others' case, you could have any number of lawyers, but in this case, you did not want to put up a senior counsel to face the battery of lawyers of Salman Khan?
Okay, so why didn't that happen, Aniket Nikam?
Because prosecution is unable to establish when there is so much evidence.
Aniket, does that seem strange to you?
There is so much evidence which is there for everyone to see.
I disagree with Ashok Singh when she says that competent lawyers were not defending the state of Maharashtra. The senior prosecutor of Bombay High Court was defending the state of Maharashtra, so it's a wrong statement to make that competent lawyers were not defending. Secondly, the aspect of the police purposely or intentionally delaying the trial, that's again a wrong thing or wrong presumption. Let me tell you that when initially the FIR was registered, it was registered for an offence of rash and negligent driving. It is Bombay police which slapped the offence of culpable homicide not amounting to murder, which Salman Khan challenged before the Sessions Court. It got rejected. He went in High Court. High Court allowed his petition. 304 Part 2, which deals with culpable homicide not amounting to murder, was set aside qua Salman Khan.
Okay.
State of Maharashtra went to appeal to the Supreme Court. So all this has taken some time. Please understand.
But
this is not a
essentially
case
today,
the
judge has categorically said, that the acquittal has happened because of two things: a botched up probe and a botched up prosecution. That's what the order really boils down to. Hitesh Jain also joining us now this evening. Hitesh Jain, your first comments on this. The crux of today's the order is that it was completely botched up by the probe and also the prosecution.
I completely agree. It's a botched up probe and botched up prosecution, because right from the inception, from lodging of FIR, the manner in which the investigation was conducted, the High Court had a lot to say about that. But I can also say that after today's order, every accused in the hit and run case or cases of similar, they will be smiling after this order, because this sets a precedent to take every possible defense and then seek an acquittal in the case. So effectively, there has been a miscarriage of justice, both qua the victim and qua the accused also, because after 13 years, we are still searching for the answers. And this and the fact that it is a botched up probe has now been also been admitted by the High Court, and the High Court has said
exactly.
In so
you shake your head, Aniket Nikam, but then who killed Nurullah? Answer that simple question.
See, I'll tell you, it's in a criminal trial, you have to prove the guilt of a person beyond shadow of any reasonable doubt. Now, the defense lawyers of Salman Khan might have taken technical pleas, but at the same time, to say that this investigation was completely botched up from day one is too much of a statement. Please understand, on the basis of this evidence, the trial court convicted Mr. Salman Khan for 5 years.
But Aniket,
now, on reappreciating this evidence, on reappreciating this evidence, High Court has come to a conclusion that no, he could not have been convicted. But please understand, there is a forum which is the Supreme Court
available. How about the FIR not mentioning the word drunken? How about the FIR not mentioning alcohol or the fact that Salman Khan was under the influence?
FIR need not be an encyclopedia. It's a settled position of law.
No, but if the entire case is one of drunken driving, then it comes down to that FIR.
But that does not mean that the FIR itself is lacking.
It is a settled position of law, Mr. Nikam,
at the first possible opportunity available to him in his supplementary statement, Ravindra Patil has said that he had consumed alcohol. Secondly, Ravindra Patil was not attending the trial. The trial court had to issue non-bailable warrant against Ravindra Patil in order to secure his attendance.
32 of the Evidence Act says that relevant facts should be taken. How could High Court not look into the statement of Ravindra Patil? 32 of the Evidence Act says relevant facts should be took into consideration by the court. So the relevant facts
exactly. A good thing you brought up Ravindra Patil, because that's my next question to Sujay Kantawala. Did the prosecution rely too much on the statement of Ravindra Patil? Did the prosecution rely too much on Ravindra Patil's statement, Sujay Kantawala?
Don't blame the mouse, strengthen the mousetrap. The point is simple. Why are we taking pot shots at all these things? The point is the learned judge took enough time. He heard the matter. He heard both the sides. Both were competently represented. I appreciate that the defense team was obviously, I mean, the best legal brains in the business. No doubt Salman could afford them. But the point is this. The judge has considered all the aspects. The judge has point-wise gone into each and every fact, the blood samples, the witnesses, the tire burst. I mean, so therefore, here is a well-reasoned judgment. Let the police in future take a cue from this judgment, and in future, whenever they make their investigations, let them not make these same mistakes. Possibly
exactly,
this will not be the result in future.
The point is, Nagma, Ravindra Patil was brought forward as a star witness, but at the end of the day, the fact remains that he had made improvements in his version later when his statement was recorded. Knowing that, why did the prosecution not bring in corroboration? And that's what the court has mentioned today, that if the witness is partially reliable, then the corroboration is required, and that corroboration could have come from Kamal Khan.
Justice Joshi was hearing an appeal. So there were the records available before him.
See, strictly speaking, in terms of law, when there is an evidence, there is a deposition of a witness, and I'm speaking as a lawyer, I'm not taking side of anybody.
Of course he is.
As a lawyer...
No, nobody is questioning the judge. The issue here is that his entire premise has been that it was a completely failed prosecution. That is what we're discussing.
And we have to respect it.
Nagma wanted to make that point.
Gentlemen, why should there be a faulty investigation, and should we not put the house in order?
Yeah, so we'll come to that. Nagma, you were saying something.
For a criminal justice system,
I think there is something to be blamed. It's the judicial system that needs to be rectified.
No, I'm sorry. I'm sorry. No. I think all the three lawyers over here will disagree with that. I'm sorry. Please don't make such statements.
One case. There are so many innocent people who are also lying.
No, we agree that there are innocent people, but don't make statements.
Why are we taking one case? Didn't Sanjay Dutt get convicted?
Fair enough.
It is an injustice to both the victim and the accused.
Our new Chief Justice of India has taken up this mandate that now there are going to be more High Court judges. He's going to appoint more High Court judges. So let's await.
I don't think we can lay the blame at the door of the judiciary simply because the judge will only examine the evidence that is put in front of him. It's as simple as that. And if the investigation is faulty, if adequate evidence is not brought before him, what option does he have but to give benefit of doubt? Aniket Nikam, I want to ask you, was too much reliance put on Ravindra Patil's statement? Why was there no corroboration of the statement that he had made, knowing that he is partly reliable, only partly reliable?
See, I'll tell you, when Ravindra Patil had deposed before the magistrate court, 304 part 2 was not there. He was deposing in a case which was charged with rash and negligent driving. Now, when Supreme Court set aside the High Court order and 304-2 came to be slapped on Salman Khan, the matter was committed to Sessions Court because it was triable by Sessions Court. The matter, when it went to Sessions Court, they called for re-examination of witnesses. At that point in time, Ravindra Patil unfortunately was not alive. So one of the major defenses of the defense of Salman Khan was that we never got an opportunity to cross-examine Ravindra Patil when 304 Part 2 was slapped against us. Now, in respect of that...
Exactly, and knowing that, would it not have made sense then to bring in Kamal Khan?
Now, see, let me tell you, let me tell you, defense wanted Kamal Khan to be cited as their witness. They have not cited Kamal Khan also as their witness. Now, I know that the burden of proof is on the prosecution, but at the same time, instead of citing Ashok Singh as a witness, Salman Khan could have cited Kamal Khan as their witness, and he could have.
Abha Singh wants to rebut you. Abha Singh wants to rebut you. Abha Singh.
No, here I would beg to differ. Because even if you say it was 304A and then 304 Part 2, issue is the substantive law was the same. Just because the charges have changed, you have to go into the fact. The fact was whether Salman was driving, whether he was drunk. These were the 2 points which need to be done. No, you please read 33A. You please read 33A of the Evidence Act, which doesn't say that if the charge changes, then everything goes null and void. No.
Once again, please read
and the Evidence Act says, no, you please read 33A of the Indian Evidence Act. Please read 33A.
Ladies and gentlemen, let's just look at some of the other aspects here.
Here the charge was altered, it was transferred from 304A
even the law
to
point has to be
304-2,
seen.
which is of a
The
grave
charge
nature.
doesn't hold good. The fact was that only 2 points had to be proved. And when Ravindra Patil's statement was in front of a magistrate, then it should have held good. It could hold good in the Sessions Court. But in the High Court, you are not ready to look into the same
No, sorry. Once again, I beg to differ. That's legally incorrect. That is legally incorrect. That submission is legally incorrect.
Expert opinion.
That is incorrect for simple reason that an evidence of a witness could be used in a subsequent judicial proceeding only when the trial or the subsequent judicial proceeding is substantially similar. Now, over here, the charge is substantially different. 304 is punishable up to 10 years. 2 years and 304 Part 2 is up to 10 years.
Abha Singh and Aniket Nikam, we're going to look at some other issues here also, and Hitesh Jain, I'll come to you on that. Just going back to the issue of Ashok Singh, and I put this question to Abha Singh earlier. The fact that he shows up so late in the trial is not something that, that is considered bizarre. The fact that he says for years he was trying to say that he was the one driving, but nobody was listening to him. That is, it just sounds plain bizarre. Somebody in a Salman Khan case is trying to tell people, including the police according to him, that he was the one at the wheel, and he's been trying to say this for 12 years and nobody listened to him.
Well, according to me, this is a criminal justice system also is based on the probabilities. It is right that the defense witness also comes at the end. And
right.
he did not come
which is
in
what
the
the judge has said in the order.
The judge is procedurally right. But from the when you look at the all the facts and the conduct, for umpteen applications were filed. There were so many applications in the High Court, Supreme Court and the trial court. And the fact that the Ashok Singh's name was never mentioned, and the fact also, forget the Ashok Singh's name, the fact that he was not driving, this fact was also nowhere stated. So this fact was always kept as ambiguous as to who was driving, and in the end this witness was introduced. So while the judge is procedurally right, but the observations of the High Court that this is a shoddy investigation, this is a botched up investigation, and we are talking about a criminal justice system, for whatever reason, whatever procedural lapses, a person can stretch the trial for 13 years, I mean, including the appeal and all. I mean, matters like Alistair Pereira and all other matters, it took 4 years right up to the Supreme Court. So what kind of criminal, so it, do we take a pride in ourselves that we take 18 years to decide a matter like this? As a lawyer,
and
I
Aniket
certainly,
Nikam,
it is a
simple question. When it's a case of drunk driving, would you not assume that more care would be taken, especially when the blood samples are being tested? Now, that's the very basic, when you have to judge the alcohol content of the person in question. But apparently, even there, the very basic thing was ignored, and yet you continue to defend the probe.
Yes,
today
that
the
is the
judge
reason.
says
So therefore,
that even the entire process of testing was flawed. You have 6 ml of blood extracted and 4 ml lands up in the laboratory.
I am not saying I am not saying that Mumbai police have been above board. There have been certain discrepancies and slipshots, yes.
But that is
at the same time saying, once again, same time saying that this is intentional, that this is purposeful, is too much of an assumption. It is misplaced for a simple reason that
a slipshot is a slipshot. A shoddy investigation is a
shoddy investigation. Sorry. There is an allegation that this has been intentional, that police has been siding.
I am not going on the intentional investigation, but whatever be the fact,
I do not agree with that.
The investigation has been a shoddy investigation. investigation.
as far as the content of alcohol is concerned, there have been statements of witnesses. The person who handed over the key to Salman Khan said that he was drunk.
Content. 1 second. If you're taking a blood sample for testing it for alcohol content, how is it that there's two different vials of 3 ml, 3 ml, reportedly 6 ml withdrawn? It's 4 ml that actually reaches the hospital for testing. That too 2 days later, after reportedly being in a refrigerator, which finds no mention otherwise in any record.
Why? What is another thing? Another appalling thing. Panchanama of the bills. They say the bills were not recovered properly. That is an elementary thing. Police cops know their investigation well. Anything they seize, anything they recover, they have to do a proper Panchanama. So today the High Court is saying not even a Panchanama was done. So this is elementary of a shoddy investigation.
1 second. Panchanama is the basic thing of any criminal trial. Panchanama was done. But the point was that there was no witness examined. The police officer or the constable who took the samples and handed over to the hospital, got them back. That police officer was
No, we are not talking about the alcohol sample. They are talking about what happened about the bill.
That you should have examined a witness. You should have examined a witness who have gotten this alcohol content.
About examining the witness or everything.
No, your statement that Panchanama was not made is a wrong statement. That's not true. Panchanama was made.
And investigation go hand in hand.
Answer the question that Hitesh Jain has brought up about the bills. Where has anyone ever seen a hand-endorsed bill? Where reportedly Sohail Khan has endorsed this bill by hand and 4 different bills of 4 different tables.
So this is an evidence of a shoddy investigation. And the question that should be asked is, are we going to fix this shoddy investigation? Are we going to demand an inquiry in the shoddy investigation? Or cases after cases will go and on the basis of shoddy investigation, there will be no justice and there will be miscarriage of justice.
Exactly. And I want to bring Nagma in on that as well.
To be asked is about shoddy investigation. Salman Khan is a secondary issue. The shoddy investigation is the most important aspect.
Acquitted Salman Khan does not mean that the case has come to an end. There is a possibility that the state of Maharashtra may appeal to the Supreme Court. There have been cases and cases where even if after High Court has turned down a judgment, Supreme Court has upset that judgment. So we are jumping the gun by saying that it has come to an end. The investigation is botched
today on the basis of the judgment we have to go.
Absolutely not.
But today on the basis of the judgment
when 304 Part 2 was deleted against Salman Khan by the High Court, Supreme Court set aside that order and remanded back the matter to the magistrate court.
And I want to bring in Nagma over here. Nagma, do you think at least a case is made out here of asking questions of the investigation? There should be maybe a separate inquiry into what really went wrong. For example, the 2 instances that were stated earlier. One, about the flawed way in which the blood testing was done. Second, whether it was established at all whether Salman Khan had consumed any alcohol or not. Apparently, that didn't even happen.
Look, I just want to say that we need to trust the wisdom of the judge. And at the same time, I don't
We're just questioning the investigation.
Salman has gone wrong in this whole thing. I don't know where Salman has gone wrong in this whole thing. I mean, like the others have said, that the judgment has gone according to the way it should have gone. So when everything has gone the way it should have gone, then where is
actually the argument being made by a large panel of lawyers is the judgment.
After 13 years today, if there
was based on an investigation that was flawed.
Then one should also accept that, and it's not about him. We need to have fast-track courts. We need to have the judgment which should have come much earlier.
How did the accident take place?
Such a long time.
Or if the accident, if at all, took place, are we not required to know this answer?
If I am not learned enough or I don't understand enough, then I'm sure that the judge did understand enough to give the judgment that he did, and he's given that judgment. The judgment
Nagma, the judge.
So the
judge is not being questioned here. Secondly, the judge has also in his order. Nagma, the judge in his order has again said, and which is one of the basic tenets of law, that it is not for the accused to prove his innocence, but for the prosecution to prove the guilt. And that's it. That is what this has come down to. So nobody is questioning the
judgment of others.
Yes, but what we are asking here, therefore, has the prosecution failed in its job? Has the investigation failed?
Why we cannot blame him for prolonging it for 13 years?
That's what he's a defense lawyer for. He is going
Sujay
to take
Kantawala.
advantage of every fault or every shoddy part of the investigation. That's his job. That's the job of the defense. But that's his professional duty.
But also, I think the High Court could have gone ahead and given the guidelines. If the High Court has found so many faults, it should have set the guidelines for the future.
That's what I'm saying.
It could have acted as a guideline for the police officer.
I agree with
so
my
the High
friend
Court
Hitesh.
has also fallen short. I mean, in matters like this, the High Court have always, after giving the judgment, have laid down the guidelines also.
They could have gone ahead. It's wrong to say that High Court has fallen short. One second, that was not the matter before the High Court. High Court was concerned with the appeal.
Well, in so many matters, there are so many matters that are not there. But the idea is we have to guide. When you see a shoddy investigation,
that was not the public interest litigation that was being heard by the High Court.
In the right spirit, the High Court has gone into the details. There are pointers over there. In future, the prosecution, the investigating agencies will take advantage of the judgment. These are pearls of wisdom which have fallen from the learned judge's lips, and they are there for us to read. So let's first appreciate the fact that the judge has definitely worked hard on this. He has delivered the judgment. He has heard both the sides, and he has made certain observations which should be taken in the right spirit. We are all bound by this judgment,
Sujay
and
Kantawala,
we should
therefore,
respect
would you then disagree? Would you then disagree with what Hitesh Jain said? Because he said that this particular judgment actually sets a negative precedent for hit and run cases in the future.
It cuts both ways.
One second,
it cuts both ways.
It does run some. It does.
Every judgment is a preliminary point of law that every judgment is based on its own facts and circumstances.
But on the principle of appreciation of evidence as to how the High Court has appreciated the evidence also forms the guidelines. Aniket, but how the High Court has appreciated the evidence also forms the guidelines and a basis for the trial court. So of course it does leave the loophole.
That does not mean that it gives the wrong precedence for all the persons who are doing
what Sujay Kantawala is saying is the exact opposite. What he's saying that because of how the judge has managed to pick holes in the prosecution's case, this in future will perhaps alert the investigators, the investigating officers and the prosecution as to what exact loopholes need to be
this was the argument of the defense. The defense pointed out to the learned judge that, sir, these are about 10-15 different types of issues which are grave instances which you need considering. So the judge appreciated it. That's it. That's the bottom line. So
this does not bring an end because there is always a possibility of this matter going up to the Supreme Court and Supreme Court taking a contrary view to the view that is being taken by Bombay High Court. So we do not know. So it's jumping the gun that we are saying that Bombay High Court has said that the investigation is shoddy and investigation is become shoddy.
But if the Supreme Court holds it otherwise, then it will reflect very poorly on the High Court in the manner in which the appreciation
of evidence.
So let's wait for whatever happens.
Today we have a judgment which clearly says that the investigation is shoddy. So that is the moot point.
Yes.
And the fact is that the people are questioning that only in the cases where high profile people are there, is there a shoddy investigation or is the shoddy investigation
so in fact,
every case?
On the contrary,
and the fact is,
high profile cases are there when there is vigilance of media, police are being extra careful. Now I agree. I do not say that I don't agree. I agree that there are mistakes in investigation. But at the same time, let's understand that this is a case which was based on the evidence of Ravindra Patil. Ravindra Patil had deposed before the magistrate court saying categorically that Salman Khan was drunk and he was involved in the accident. When the matter went to Sessions Court for the purpose of trial, when the charge was altered and amended, Ravindra Patil was not available. Now taking benefit of this situation and circumstance, much hue and cry was made before the Honorable High Court that we could not get an opportunity to cross-examine Ravindra Patil. Now section 33 of the Evidence Act says that the evidence of any witness while given in a judicial proceeding could be used in a subsequent judicial proceeding provided the proceeding is between the same persons and it is substantially similar. Now in a case where the offence was 304A and altered to 3042, it's a point of argument, point of moot that whether it is a substantially similar case or not. But his evidence, of course, could have been used for the purpose of nailing him for an offence under 304 Part 2. But Honorable High Court has taken a different view, and we respect the verdict and the judgment of the Honorable High Court.
Whatever, but the shoddy investigation gave.
Okay, so on the point of Ravindra Patil, there are still many questions remain. Did the prosecution have no other option now that Ravindra Patil's statement seemed a little shaky? The High Court has, of course, disregarded it completely. On that point, we're going to head into a very quick break. And on the other side, we also look at the broader question: what happens to the justice for the family of Nurullah and the 4 others who've been left disabled in this hit and run accident? We are going into a quick break. Back in a couple of minutes.
Welcome back. Thanks very much for staying with us. Also saying good evening now to former IPS officer A.A. Khan as well as former IPS officer and advocate P Singh. Good evening, gentlemen. Mr. A.A. Khan, if I can just come to you for your opening comments. We've been discussing and debating the fact that the judge has categorically in his order blamed prosecution which has failed to prove charges against Salman Khan and an investigation which was conducted in a faulty manner with scant regard to procedure, thereby blaming the Mumbai police also for the way things were conducted in the early stages of this investigation. Your first comments.
Well, the fact remains that the prosecution failed to prove that Salman was driving the car and that he was under the influence of alcohol, and that was a result of various lacunae in the investigation which needs to be inquired. But there will have to be an inquiry on part of the government to find out how the prosecution allowed these discrepancies to enter while preparing the case, and the Director General of Police will have to see how the police...
So you're saying yes, the prosecution had major loopholes in their argument, but you are saying that there were glaring errors in the investigation itself.
Yeah, apparently so. Even the appellate judge has pointed out several glaring errors in collection of blood samples, in submission of blood samples, in taking of the blood samples initially also. So there have been glaring errors, and one's going to find out why they were committed and how they were committed, who committed
Exactly.
them.
So P Singh, was this sheer carelessness? Is this as simple as that, or was there something more?
Well, that's very difficult to say because it would be conjecture. Whether it was carelessness or...
No, I don't think it is carelessness at all, because police cannot be so naive that they would falter in these basic things. You know, these fundamentals are never forgotten. There's something called a friendly investigation in the police, where police tells the accused that, look, we will have to prosecute the case, but we will go. We are going to make the evidence speak.
I think that's
it is pursuant to this concept.
Okay, so you're really setting the cat among the pigeons.
That this has happened.
It's a presumption.
Very serious
I don't
allegation.
agree with that presumption.
Very serious
We can't go around presuming.
Had
An inquiry has to be conducted.
Let me tell you,
An
Bombay
inquiry will be
police would not
conducted.
have invoked
And
304
they'll be able
part
to
2 against
pinpoint
him.
who was
They would have limited it to 304A, which is rash and negligent driving. Had it been a friendly investigation, 304 part 2 would not have come into the picture.
Aniket Nikam is
I
saying
think
this is a
we are
very
going way
serious
ahead of
allegation.
us by already presuming what was wrong.
Part 2 was done by the magistrate after examination of evidence.
Sorry, 3042 was charged by Bombay police. They challenged it. They went to High Court. High Court said 304 part 2 is not applicable.
Levied by the
Maharashtra
police.
State, Bombay police went in appeal to the Supreme Court saying that 304 part 2 should be applied. Supreme Court said that you please go back before the trial court. Let the magistrate take a call whether 304 part 2 will apply or not.
I don't know what the discussion is about.
To say that the Bombay police was being friendly is too much of a statement.
What are you discussing? I've not been able to find out. What are you trying to prove?
This is the charge made by P Singh is very serious.
This is a friendly investigation, friendly prosecution, friendly trial, and we have brought it down in 2012 before everyone. We have presented the documents on this.
Mr. A. Khan.
Each and every
one point I'd like to make here, that we are deviating from the main subject. The main subject is that he was acquitted due to lack of evidence. There was nothing to prove that he was drunk. There was nothing to prove that he was driving the car. Now, why the police, if the police presume that he was driving the car and he was drunk, why did they fail to prove it? Why didn't they adduce adequate evidence? And why didn't the prosecution follow it up? So that is the difference.
And P Singh says for that because they intended to do it that way.
But in fact, let's get Nagma in on this.
Presuming-
Nagma, very quickly, you were saying earlier, why is it that cases involving stars are talked about? But this also brings up this aspect, right? The issue here is that there is an allegation that's been made here, a conjecture that's been made here that this was perhaps a friendly investigation. Now, friendly investigations also only happen to high-profile people.
I don't agree with that
Friendly
term.
investigations are not conducted for the common
There's no
man.
such thing.
You don't allow me to answer the question.
Go ahead, Nagma. Gentlemen, we'll allow Nagma to speak, please. Yes,
This is a
Nagma.
known concept.
I
second,
think
Nagma.
that's entirely incorrect.
Allow me to answer,
That's
please.
I don't agree with that statement. You are presuming, when you say friendly investigation, without evidence, you're presuming that Salman
Okay,
was
Mr.
guilty.
A. Khan, we'll get
presume
you
that
to
he was
respond to
drunk and
Mr.
driving
P
the
Singh
car.
in just a minute. We're just trying to get Nagma's response
Friendly
to this. Give us a
investigation
minute.
is weaken the case.
1 second. Gentlemen, let Nagma make her point, please. We'll come back to you.
Look, I've seen this happen in many cases. We've seen Arushi's case, and there are many other cases where they faltered very badly in the investigation. And I don't think this is Salman's fault in this entire investigation. Having said that, I'm not taking his side. I'm just trying to say that the judge has come to a judgment. He's acquitted him. But at the same time, the judiciary needs to be, the judiciary needs to be, overhauled. There has to be a betterment in the investigations. Look at what happened to Jia Khan's case also. I mean, they're not able to,
YP Singh,
conduct.
YP Singh, you make a strong charge.
And
give us specific points because Mr. A. Khan strongly disagrees. He thinks you're getting ahead of yourself, and it's a dangerous presumption.
We are digressing.
Specific instance why you have used the phrase friendly investigation.
Let me tell. I have been asked a question. Let me answer.
Yes, Mr. YP Singh versus A. Khan.
One-star witness. That was Kamal Khan.
You say
for smaller witnesses, you take a statement under 164. For Kamal Khan, you don't do it. Then Salman Khan disappears. You don't take his blood sample. You take his blood samples the other day during the prosecution when all these things are happening. Police is pursuing the case. On one hand, the inspector goes to the court to pursue the Salman Khan case. At the next moment, he goes to Salman Khan's residence to say, Mr. Salman Khan, our senior officers want you to be present in the police welfare function. And where he goes and the commissioner of police claps for it. Is this not friendly investigation and friendly prosecution? Is it propriety? Does it abide by the rules of natural justice?
And this is a police insider saying this. This is someone who's worn the uniform saying this.
On the other hand, you are requesting him to come for functions.
Participating in police concerts. Let me tell you, Salman Khan was an accused. He was not convicted when he was participating in those concerts. When he got convicted, his conviction got stayed by the High Court, and today he was at the mercy of the police. So a person is presumed to be innocent unless proven guilty.
He was at the mercy of the
say that he was convicted, he was accused.
No, Aniket,
that's one thing. Number two. One second. Number two. He was to say that this investigation was friendly. It's completely wrong. It's completely wrong. For the simple reason, one second, for the simple reason that had this been a friendly investigation, Salman Khan would not have been tried for 304 Part 2. It is as simple as this. He might have been then tried for 304A, which is rash and negligent driving, but he would not have been tried for
and if it was a friendly investigation, how come he was convicted by the lower court?
Okay, Sujay Kantawala.
Here today his appeal has been allowed. The conviction has been converted into an acquittal. So it would be very unfair to blame the police or cast aspersions by saying that it was a friendly investigation. There is a learned judge of the lower court, that's a trial court, that has convicted him. So here we have two judgments. And one is a conviction, one is an acquittal.
That is also equally bad. On the basis of Shoddy investigation, why convict a person? Because that is also a miscarriage of justice.
Sorry, that's an opinion that High Court has taken, but that opinion again may be set aside by the Supreme Court. Let's not say that because High Court has said it now that the investigation has become completely shoddy. We have to
go by the judicial verdict. No.
If the matter goes to the Supreme Court takes a different view, we all of us will be sitting again and saying, no, we think that the investigation was proper.
And then when all cases go ultimately to the Supreme Court, you say there are delays in the judicial system.
Mr. A. Khan, you've rendered just distinguished service to the Mumbai police, and today you have someone who has also been in the Mumbai police, Mr. YP Singh, saying that this is a far too familiar scenario where for some reason there seems to be these glaring errors that have been made in the investigation. Can it just be a coincidence, Mr. Khan?
Whatever he calls friendly investigation, he may have seen in a shorter span of service, but I have not seen what is called friendly investigation. It may be shoddy investigation, I grant you. It may be slipshod investigation, I grant you.
So then again, then again, the question arises that in a high-profile case like this, when you know immediately that you're dealing with somebody
what do you know?
How can anyone be conducting a shoddy investigation when you know immediately that you're dealing with an extremely high-profile case?
So what is
high profile or no
shoddy investigation?
Shoddy investigation is not something which is done deliberately. It may be the incompetence of the person, it may be the circumstances. So it can't be said.
No, shoddy investigation certainly cannot be circumstances. It can be. It has to be with the person only.
This was being supervised by senior officers.
Investigating.
So DCP, additional CP.
Circumstances do not investigate
somebody
themselves.
Died.
Shoddy investigation, the blame rests with the Mumbai police.
Somebody died in this. There is an
So
Indian
we
citizen that
have
has
also
died.
look at about the fact about the justice for the victim also, the person who has died.
Exactly, and I would
justification
so we are
to
only
Shoddy investigation.
So therefore, don't look
as
at
we-
it only
as
from
we-
the point of Salman Khan's point of view, but one person has died.
Yes.
So are we not going to talk about the justice for him?
Absolutely.
Absolutely.
From this judgment.
In fact, if anything, that is the victim. Nurullah is the victim in this case. The four other people who have been
Let us
disabled
talk
for life
about that.
are
Time and
Let's
again,
spend some time.
that Salman's-
Merely because he has nobody in the family,
No.
so then we just leave him to die, and we say that okay, there will be no answer how you died.
It is said that Salman deposited 20 lakhs or whatever it is immediately. That has not been released.
But
because the
money
court-
cannot buy the death. I mean,
that's a
idea
civil
is
matter.
money an answer for
No,
a
but
death?
some kind of
and so
compensation.
somebody dies and you say
That
we
has
give the
nothing to do
criminal-
with criminal
But how are you
the
presuming
Okay,
that
and we
Salman
take a
Khan is
final
responsible
comment
for
from
this?
Nagma.
criminal justice.
We take a
I'm not
final
saying
comment from
Salman Khan
Nagma
is
on the
separate,
issue
they're
of
not
justice.
together.
You are saying, Nagma, that Salman Khan
These are
cannot be
legally
blamed. Ultimately, what has
incorrect
happened
propositions.
is justice. But what about justice for Nurullah? Where's the justice there?
I am talking about the fact that we're all sitting here to ask for justice for Nurullah and the person who's died. But the person who died cannot be brought to life, and the person who has a life, his life cannot be
So that
taken
means if a
away.
person
I mean,
is died, you should
give
allow
him
him
a
to die
break.
and you should not
I mean, if the
investigate
judge
how you
has
died.
given a
Nagma, you are a political leader. Nagma, you are a political leader. One person has died. Nagma, you are a political leader. So that means a person is died, you let him die.
I'm saying this
Are
with
you saying
complete
Salman was
responsibility.
convicted, you'd be
I
brought to
think
life?
you are questioning the ability of the judge.
No,
to have
Nagma,
done
so you
the
mean
case
to say a
of the
person is died? Let's forget about the fact that he has died.
Nobody.
I think this is very insensitive
talking
comment.
about-
Nagma, you are also a political leader. Don't make insensitive comments.
This particular, let's not talk about this
You're
particular
alluding-
case. But
Nagma, you are making a very insensitive comment. Person has died, you forget. So there is nobody. Let's not get into that question.
I think you're talking-
This is very insensitive.
Nagma, I must
Very frankly, you don't know what
that
you're
at no
talking about.
point in this
We are saying
Nagma,
that-
you are only looking from the eyes of Salman Khan.
Nobody has questioned the wisdom of the judge.
We're not
None of the
questioning the
panelists here
judge.
tonight have done that, Nagma. The only question that has been asked, here tonight is whether or not the investigation was shoddy and whether or not the prosecution completely failed to make their case. Those were the questions that we've asked, and those are the questions that we're going to continue to ask to our next round of panelists who join us on the other side of a very short break on the News Hour at 10. Thank you very much, Nagma, and all the gentlemen for joining us on the first debate tonight.